The Dodd-Frank Consumer Protection Act was signed into law in July of 2010. 2 years after that, there's still a tremendous amount of misleading information and confusion surrounding the law. I'm Frank Gregoire. I'm a real estate appraiser from St. Petersburg, Florida. Let's take 5 minutes to talk about 4 things you need to know about the Dodd-Frank Act. Number 1, the Dodd-Frank Act, although it amended dozens of existing statutes, amends 3 that have an effect on real estate brokers, salespersons, and real estate appraisers. It amends the Truth in Lending Law, or the Truth in Lending Act. It amends the Equal Credit Opportunity Act, and it amends the Financial Institutions Reform and Recovery Act. Number 2, the amendments to the Truth in Lending Act impose sweeping changes on the manner in which real estate appraisers are retained and compensated for real estate mortgage loan transactions. These amendments are among the most confusing parts of the Dodd-Frank Act. First, the amendments to the Truth in Lending Act sunset the much belied Home Valuation Code of Conduct. In its place, Appraisal Independence standards have been imposed. The Appraisal Independence standards prohibit certain actions by persons that have a financial interest in a real estate mortgage loan transaction. It's important to understand that real estate brokers and salespersons have an interest in a real estate finance transaction. And as such, certain actions by those interested parties are strictly prohibited if those actions have an intent on affecting the independent, objective judgment of a real estate appraiser. Those prohibited actions include extortion, coercion, bribery, intimidation. So you can't do those things to a real estate appraiser if the intent is to affect his value estimate on a property. Specifically allowed under these independent standards is to provide the appraiser with additional information about the subject property or about comparable sales which may have an effect on the value. It is also specifically allowed to ask the appraiser to correct errors in an appraisal report. Next, the amendments to the Financial Institution Reform and Recovery Act that are part of Dodd-Frank provide something that doesn't exist anywhere in the federal statutes or in Florida statutes, and that is a definition of a broker price opinion. It specifically states that a broker price opinion is an estimate of the probable selling price of a property that is prepared by a real estate broker, a real estate agent, or a real estate salesperson. These same amendments specifically state that a broker price opinion cannot be the sole basis by which a lending decision is made for a consumer finance transaction. Finally, the amendments to the Equal Credit Opportunity Act. For several years, borrowers have been entitled to a copy of the real estate appraisal after the loan transaction or the sales transaction closed. The amendments to the Dodd-Frank Act expand the rights of a borrower and give you important information that you should provide to the borrower. The borrower is now entitled to a copy of any valuation that was prepared to assist in making the lending decision. And they're entitled to copies of those reports 3 days prior to the closing of either the loan transaction or the sales transaction. These valuations could include the real estate appraisal, any broker price opinion that was prepared, any comparative market analysis, or any automated valuation model. This provides important transparency and information to the borrower and makes sure that they are fully informed of all of the valuations of the property prior to signing their name on those important loan documents. You can make points with your borrower by making sure that they secure this valuable information. Well, we've just talked about 4 important provisions of the Dodd-Frank Act. I hope that helps clear up some of the misunderstandings that you may have encountered.